Hold on. All right, there we go. Um, Afternoon, everybody. Glad to see such a great turnout because this is your future. I was on a broker meeting with NAR earlier today. They gave an update about the lawsuit that's going on in Kansas City. And a ruling on that should happen around the 10th of November. But no matter what the outcome of that is, um, there will be years of appeals. So we won't really know an answer. Our hope is that NAR KW, who was involved, and I can't remember what the umbrella name for Berkshire Hathaway, but they're also the ones still in it. But we're hoping that there'll be no liability. So regardless of what that outcome is, because behind this, there's other lawsuits and the DOJ is in here and whatnot. We have to change the way we're doing business. We have to be the the claim is that we are not upfront on how we get paid, and both buyers and sellers are paying more for a property just because the established commission structure that we currently have. I will say this, I said it in my Calabasas meeting on Tuesday. Commissions are negotiable. There's nothing that is, well, this is the way it is. That does not exist in our profession. Commissions are negotiable. So how do we make sure that we're paid? Because nobody wants to pay us. Sellers don't want to pay us. Buyers agents and buyers don't want to pay us. How do we make sure we're paid? We have to sell our worth. Um, uh, you uh, uh, you have to sell yourself, just as you're selling yourself to a listing agent. I mean, to a seller to get the listing. You have to sell yourself to the buyer to say, I have value here. I am an advocate for you on your side, because the argument I've seen um, uh, is that is that oh, they'll just go to the listing agent. Well, the listing agent has a fiduciary duty to the seller. So are they really servicing the buyer? You have to sell yourself. And in other states, it is mandatory to uh, to do a buyer broker agreement. Um, so um, so that's how you have to get this signed. Okay. So where do you start? Well, somebody I admire, who is a broker of another firm, suggests that you start with the listing agreement. So that's where we're going to start, and I'm going to show you why. Go. All right. So what you should be seeing is the residential listing agreement. Thumbs up. Somebody, yes, I got you. Okay. So this is where you start this conversation. Why? Why do you start this conversation? Because this is where compensation is agreed to by the seller in the listing agreement. So you can point out to them, Mr. Buyer, this is a listing agreement that we present to the seller. And the seller agrees to pay the compensation of the purchase price and whatever that number is, 5%, 6%, whatever that number is, they're agreeing to pay that amount. And then we show them a little further down in section number D that seller has been advised by broker's policy regarding cooperation with and the amount of compensation offered to other brokers. Broker is authorized to cooperate with and compensate brokers participating through the multiple listing service by offering to MLS brokers out of brokers' compensation out of this 5 or 6%, X%. So that way, people, because everybody thinks, oh, you're getting so much money because you're getting 6%. Well, excuse me, but we're sharing that compensation with somebody else. So that's where the conversation starts, is that this is how we get our compensation, Mr. Buyer, from the seller agreeing to cooperate with other brokers through the MLS and offer part of the compensation being offered to the listing broker. That's all you have to do. So that starts the conversation. And then it continues to, well, in the event that the seller isn't offering compensation, because they're under no obligation to do so. And as I said, these lawsuits, part of two of the companies that have settled, one Remax, the other one Anywhere, which is the blanket corporation for Coldwell Banker and other brokerages, part of their settlement agreement is that they're not going to force sellers to offer compensation to the buyer's broker. So, number one, you need to look out in the MLS, because there is a section in the MLS that sees CBC, I believe, this is the initials, and they will say the amount that they're being offered, and that could be a percentage, and now that could be a cent, it could be zero. And so you need to know what is being offered in the MLS, because the definition of our MLS in California is a place to offer compensation. And that's in the definition in the through the state. So so that's so you need to know what they're offering. And that's why you need a buyer broker agreement, because if you know what they're offering, then you can further your conversation with your buyer. So start with the listing agreement, and then we're going to move on. Let's see. Hold on. Here we go. Okay. You should be seeing, correct me if I'm wrong, the buyer broker, the buyer representation and broker compensation agreement. Thumbs up if you're seeing that. I see it. Okay, great. So this is where the conversation starts with your buyer in regards to compensation. Okay, so starts with that the buyer grants the broker, not you, the agent, but the brokerage, because commissions are paid through the brokerage, beginning on this date and ending X amount of days later. Not a date. It starts on a specific date and then it goes for a number of days, either 30 days, 60 days, 90 days, whatever that day, that amount of day is, amount of days are, excuse me. Upon completion of a resulting transaction, whichever occurs first. So it goes X amount of days, either until you get into a transaction and that closes, or it expires. And this is a non-exclusive right. It defaults to a non-exclusive right to represent buyer in acquiring real property or a manufactured home. Number 2 says Mr. Buyer has no other agreements of compensation to anybody else except where he identifies these such people. So that's number 2. Now, can the buyer have other agreements with other brokers? Absolutely. Because remember, this is non-exclusive. So there could be other agreements. Number 3, the property to be acquired, it could be as broad as a location, a city, a county, or a price range, or you can specify a specific property or a couple of properties, or you can attach a list. Say you're going out on, you're taking a buyer out and you're showing them 5 different properties. You can attach an addendum and list the properties on the addendum. So it could be general, it could be specific to a property or a couple of properties, or it could be a whole list of properties. So that's section 3. Section 4 is where we get to the nitty-gritty as to how much are you going to pay me. Remember, sell your worth. I mean, buying a property is a very complex transaction. I mean, it's a big transaction. There are state requirements, state disclosures, and they need somebody to guide them through the process in order to purchase this place. And yes, non-exclusive means there can be other brokers working with it. There was a question. But they need to list those other brokers. So you put in a percentage, or if it's a flat fee. So 2 would be at the flat fee, a percentage, and if our brokerage, there are brokerages that have a flat fee commission on top of the percentage. If that was the case, you would put 2.5% or 3% or whatever it is, and that dollar amount, 255, whatever that is. So 4B, we go into the broker shall be entitled to compensation specified in paragraph 4A from buyer if during the representation period, during those number of days or any extension thereof, buyers enter into a listing agreement, an agreement to purchase, lease, or otherwise acquire any property described in paragraph 3. Remember, paragraph 3 could be an area, a specified property, or a list of properties. So that's saying that if we get into an agreement to purchase, lease, or otherwise acquire property, Mr. Buyer, you owe this compensation. Broker involvement. What does broker involvement mean? So this clarifies exactly what, and this is on the non-exclusive representation, which once again, this is the default. Compensation is payable only if there was broker involvement with the property. Broker involvement means any of the following: Buyer physically entered and was shown the property by the broker. Broker showed the property to the buyer virtually. Buyer submitted to seller a signed written offer from buyer to acquire, lease, or exchange or obtain an option, or the property was introduced to the buyer by broker, or one of which broker acted on buyer's behalf. However, merely sending buyer a list of properties, that's also called a drip campaign, shall not be deemed buyer involvement. So you need a little more than, hey, I sent that property to you. Well, you may have sent it to me, but you didn't do anything else. You didn't call the listing agreement saying, hey, I'm sending my client to your open house. And by the way, I'll get on my soapbox here. If you're selling your worth, part of your worth is getting in your car and showing that property to your buyer. That's part of your worth. Just saying, oh, here's a list of places, go see them. How is that showing value? You now have to justify how you're being paid. And so many agents don't actually walk into a place with their buyer. I understand there's conflicts. You can have somebody else walk them in. You can do a little more than just send them a list of open houses and say, go to these open houses. I'll give the listing agent a call just so that you kind of registered your buyer. It takes a little more than that. That's my opinion. So anyways, so that's what broker involvement is. Any questions on broker involvement before I move on? Not seeing any. Okay. Buyer acquisition, 4B2. Buyer acquisition, exclusive representation. So, oh, I see a chat. No. Okay. You can make this agreement exclusive, meaning you're their representative. No matter what, you're their representative. So this agreement shall be exclusive and irrevocable. Now you have to explain irrevocable. So many listing agents don't explain that to their clients, because I get the calls saying, I want to cancel this. And the listing agent doesn't want to cancel it. Well, I just want to cancel it. Well, I'm sorry, you've signed a contract that says the contract is irrevocable. What does that mean? That means it can't be canceled unless by mutual consent. Both parties need to agree to cancel it. So if I, as the broker, don't want to cancel it, I don't have to cancel it. That's why if listing agents, if you're sending me a cancellation of listing, I want to know why you're canceling that listing. I want a reason, just because I want to, because it's my listing. Listing belongs to the broker, so I want to know why we're canceling this. I mean, I'm probably still gonna cancel it, but I still would like a reason why. So, anyways, so you need to explain that it's irrevocable. The broker will devote time, resources, and assist buyer in finding, acquiring the property in the expectation of being paid for broker's fees. Broker is entitled to compensation if buyer acquires property during the representation period with or without broker involvement, even if another broker is entitled to be paid representing the buyer. That means the buyer goes to somebody else, writes an offer, gets an accepted offer by with that other broker. They're being paid maybe through the seller, maybe not. Maybe they can't have an exclusive, buyer broker agreement, but they can have maybe a non-exclusive buyer broker agreement. And so that broker gets paid, but Mr. Buyer, you still owe me this money. So that's what that means. Buyer indicates any person or entity other than broker related to buyer or whom any other manner acts on buyer's behalf to acquire property described in paragraph 1. Okay. So that's how you make this agreement exclusive, by checking that box. So cancellation of the buyer representation agreement. So it can either be canceled by the buyer or the broker by giving written notice to the other. This agreement shall be terminated if 1B1 applies, meaning non-exclusive, upon receipt of the notice, or you can put in X number of days after receipt. So let's stop there. On receipt of the notice. So buyer or the broker give notice, we're canceling this, and it's non-exclusive. So if no days are put in there, it's canceled then and there. That agreement is canceled. So, or if paragraph 4B2 applies, that means it's an exclusive representation. 30 days after receipt of the notice, buyer shall nonetheless be entitled to compensation if during the representation period or any time specified in paragraph 4E, buyer acquires a property for which there is buyer involvement, provided the broker delivers to buyer a written list of those properties for which there was broker involvement. A written list of broker involvement properties shall be delivered to buyer within 5 calendar days after effective date of the cancellation. Before, during, and after the 5-day period, buyer is advised to notify any other broker of broker's rights under this paragraph. Okay. So what this means is you need to give your buyer a list of all those properties that involved buyer involvement. So we're going to stop here and we're going to go look at that list. Okay. What you should be seeing is notice of buyer involvement of properties. So this notice is given to the buyer. It shows the representation period, the start date, and how many days after it ends, and the compensation agreement, and the buyer broker involved properties. And it goes into detail about what those involve, what is a buyer broker property, and you just list the properties that have buyer broker involvement. Or you can attach a list if it's a really long list. Number 5, notifying new broker. If buyer intends to enter into another buyer representation agreement with another broker, buyer is advised to provide this notice to the broker. Failure to do so may obligate buyer to pay 2 commissions. So it goes back to that. Do you have any other agreements with any other brokers? Okay, I see we have some. You're not seeing the notice of buyer involved properties. Is that what everybody's saying? No, you're not. Okay, wait, hold on. All right, okay, let's do this. Oh, I see how we're doing this. Okay. Okay. Now you should be. Okay. So now you're looking at the notice of buyer broker and you're seeing what I'm. So in 4, you list the properties. It's advising the buyer to notify the broker, and the date of this note the notice of broker involved properties is being provided to the buyer on what date, and the buyer acknowledges it. So any questions on the buyer involved notice of broker involved properties, and you would give this, you can give this at any time during the course of the agreement. Definitely you give it at the end of the agreement. Okay, any questions on that? I'm not seeing any, and I'm gonna go back to this. Okay, so now we should be back to the, oh, actually, I'm gonna stop there because we were talking about cancellation, and nope. So you now should be seeing cancellation of broker representation. So number 2 says it's a notice of cancellation of broker representation. The representation may be canceled by either the buyer or the broker, or both, by signing the applicable box below. So by signing the applicable box below this paragraph 2, either the buyer broker hereby gives notice. The effective date, if there's no written agreement between the buyer broker, if there's a written agreement and such agreement is non-exclusive, it's immediately. Or if you put in X number of days after after um, after the okay, the question is there, guys, I really prefer you put the questions to everybody, not to me personally, so that everybody knows what the question is. Is there a period after the agreement expiring that still provides compensation period protection, excuse me, like in listing agreements? The answer to that is no, because um, only if you've extended a couple of days after that is there protection. Or if it's an exclusive, it's 30 days after notice is given. And that's the protection period. If you have an exclusive for all or any properties shown, do you still need to have a list of the properties shown? You should. You should still give them a list of the properties, sure. Even though it's any, it only goes to show that you were doing your due diligence as their representation and showing them properties, or had involvement in these properties. So, so I would do that too. Yeah.
I have a question. When we provide the list, you said you could attach a list. What I usually typically do when I'm showing properties to keep record of everything that I've showed them is I print out the MLS listing page for each property. Would it be okay, just because I keep them in little like files, can you just attach all of those to the back of that? Would that be acceptable, or do you want just an itemized list?
Well, it specifically says list.
Okay.
You know, in thinking like a lawyer would think, is there ambiguity there? And I would have to say, well, you didn't attach a list. You know, so I would say you could do that, but I would also include a list because it's saying a list.
Okay, fair enough.
You know, lawyers get literal, so that's why I say that. So, anyways, so we said the effective date is, if it's non-exclusive, it's immediate, or if you put in number of days. If it is an exclusive representation, it's 30 days after the receipt. Now, why do they do 30 days after the receipt? Because if the buyer sees a property and it's an exclusive listing, an exclusive agreement, and they cancel, and if there wasn't this 30-day waiting period, what's to stop the buyer from going to the listing agent and you know um and going to them directly. That's kind of this 30-day waiting period, the reasoning for that. That's what they said. Number B3 says, regardless of the agreement between buyer and broker, the parties may agree to mutually cancel buyer representation immediately. The last signature in the mutual cancellation box. So the notice applies to all properties that may be subject to buyer representation, or you can limit it to only the properties listed. Broker will not be buyer's agent during any negotiation or transaction that results between buyer and seller regarding any property. Any questions that buyer has about the property shall be directed to the seller's broker, if any. Meaning that we don't have we no longer have an agreement, and you may owe me money, but I'm not going to be involved in that transaction. So compensation due to the broker, a written broker representation agreement provides for compensation in the event of cancellation of the agreement. Buyer agrees to pay broker as specified in the written agreement. So form BRBC, which is the buyer broker agreement, and then also the broker involved, those agreements. Compensation shall be paid as specified in paragraph 3. Buyer to obtain other advice. Broker advises buyer to obtain real estate, legal, tax, and all those. So so if only one party is canceling this agreement, so it's either signed by the buyer if the buyer's canceling, or the broker if the broker's canceling, or by mutual, there's a place to sign by both. All right, so section 3 on this cancellation only applies if paragraph 2E2 is checked above and both parties sign to, what is 2E2? Just so we know, 2E2, compensation shall be paid as specified in paragraph 3. So this is what, if that is checked, this applies. So just like on a listing, cancellation, you can have, there's different ways to say how you're compensated. So the first way, subsequent acquisition of property during the representation period or extension for which there was broker involvement prior to the cancellation, the amount of compensation specified in the written agreement, if within X calendar days after the cancellation, actually, Omid, I stand corrected. You can have that safe haven here with, if you check 3A. So this is that safe haven of X calendar days after the cancellation. There's this kind of cooling down period. Will the buyer be able to, I've got something. Will the buyer, to finance the buyer broker. Okay. I'll address that later. Okay. So, so subsequent, so this is that safe haven. If you 3A is that safe haven paragraph, or B, the buyer is going to compensate you for out-of-pocket expenses. You can put a dollar amount. C, broker to receive a referral fee, and there's this, you would do a separate referral fee, or broker to receive compensation from seller, and pursuant to a separate agreement will require compensation from the seller as compensation to the services, or no compensation. Subsequent acquisition of property during the period or extension, the amount of compensation specified in the written, if prior to the end of the representation period specified in the written buyer representation agreement or any extension enters into a contract. So that's regardless of broker involvement. And so that this paragraph is applicable only if it's an exclusive representation. Okay, so those you can choose any one of those options, and then everybody signs it. So this is the cancellation, and I'm losing my voice. Okay, any questions on the cancellations before I go back to the agreement? None. All right. Okay. Okay. So we've now covered 4A through C. Accounting of payments. If anybody other than the buyer compensates broker for services covered in this agreement, FYI, seller or anybody else, that amount shall be credited. So this is important because this is where you're going to explain to the buyer, yes, you're signing an agreement to pay me this amount. But if anybody other than you pays me, meaning if the seller agrees to pay my commission, because remember, Mr. Buyer, I showed you the listing agreement. So the seller has the capability in their agreement with their broker to cooperate and to pay me through them, then that amount, is credited to the amount you owe me. So if you agree to pay me 2.5%, and the seller is offering 2.5%, what do you owe me? You owe me nothing. So that's important. This is important. 4D is important, that you need to make sure that your buyer understands, hey, if I get paid somewhere else, I'm not double dipping here. If I get paid somewhere else, you don't owe me. Okay. So and then D2, if third party payments received exceed the buyer's obligation, the excess amount shall be paid to the broker. That's the default. So if you're only paying me 2.5%, I wouldn't say only, but if you're paying me 2.5%, but the seller is offering 3%, the other 0.5% goes to me. Or you can say, hey, you're paying me 2.5%. If the seller pays me more than 2.5%, then whatever that amount is over it, I'm going to be the good guy and I'm going to credit it to you. So there you go. Or you can say you can say credit the excess amount shall be credited shall be split between the buyer and the seller. You can say that. So, that's one way to do it also. So anyways, and then D3, authorization to include commission in offer. Buyer authorizes or does not authorize buyer to include a term in the buyer's offer of obligating seller to pay broker directly or through escrow for any compensation that buyer owes broker. It's just like in the listing agreement that the seller agrees that whatever the seller owes the broker or any of the brokers, it's done through escrow, and you're authorizing me to deduct it from proceeds and pay that way. This is saying anything that the buyer owes me, is deducted and paid through escrow, paid by a third party. Okay. So that's what that says. Additional broker right to compensate. Brokers shall be entitled to the compensation provided in paragraph 4A if within X calendar days after the expiration. Here's the safe haven clause here in the agreement. So even in the agreement, you can extend it X amount of days, just like in the cancellation. So that's what that is. We're still in 4E. So that's what that is. We're going to F. Disclosure of anticipated payments to broker by others. Broker prior to writing an offer on the property or prior to showing the property will disclose to the buyer an amount of compensation broker expects to receive from a third party on that property by providing buyer with either a copy of the MLS listing showing the cooperating compensation offered. So your MLS printout, which I don't necessarily like that idea, because in order to show that, oh no. Right now they're showing compensation to the public. So it's on the public facing. But guys, just know that printing out and supplying your buyer with the agent's MLS sheet printout that has private remarks in it, that's a violation. You're not supposed to do that, because there's information in there that is between brokers or between agents. So that shouldn't be shared, like codes to the complex. That shouldn't be shared with buyers. So if the compensation is showing, which I believe all MLSs are doing, they didn't used to do that, on the public facing printout, then you can supply them with this, or on a separate document called the anticipated broker compensation disclosure form. It's called the ABCD. So we are going to go to the ABCD. God, I don't know why I'm losing my voice. Sorry. Okay. So ABCD. And all this does is it gives them a list, and they get to initial it, of the property address, when you showed it, what was the compensation offered, and what was the source of that compensation offered. Was it the MLS? What was it? A CBC? CBC is not blood tests. It is the cooperating broker compensation agreement. Cooperating broker compensation agreement. So that's what the CBC is. So that's a separate agreement between brokers, and you use it a lot of times if it's a listing that's not on the MLS. You need to fill that out before you show that property, so that you have in place what is being offered on that property before you show it. So or a lot of times during a transaction, then that form is used if you're changing the amount of compensation. So say you're the buyer's agent and you're saying the transaction is going downhill, or your buyer wants too many credits or something, and you say, okay, tell the seller I'll cut my commission, I'll cut it. And then, but brokers have to agree to it. So that's what the CBC is. So you would list all the properties that you showed and how much the compensation was being offered, so that the buyer knows, hey, I've agreed to pay you 2.5%, but on this property, I the seller's only agreeing to pay 2%. So I'm going to have to make up that 0.5%, or ask the seller to make that up, or seller's not offering anything, which could happen suddenly now. So you can say, hey, I showed you this, but seller's not paying, but we have an agreement, so that means it's coming from you. It doesn't end there. There is still a mechanism within the RPA, even though the seller says, I'm not offering you any compensation for this, you can still ask for it in the RPA, and I'll show you how to do that. Okay. So, so this, any questions on the anticipated broker compensation disclosure? Not seeing any. Then we are going to go back to my broker. Okay. So we are back to this. Okay. So we were on F and we went over the ABCD. And broker independently, so disclosure of anticipated payments, broker independently or through escrow will disclose the final compensation broker receives from anyone other than the broker. And the buyer is responsible for payment of compensation if third party does not pay as anticipated. So if the seller's not paying, nobody pays, then hey, you owe me. All right, timing of compensation upon completion of any resulting transaction, just like in the listing. If acquisition is prevented by default of buyer, meaning the buyer just up and decides not to, technically that buyer still owes the compensation. Now, I have these agents who say, I want to go after the buyer. It is true. Yes, you are owed this compensation. It is a fight. I'm not going to lie to you. It is a fight to enforce that. So anyways, it just is. If acquisition is presented by a party to the transaction other than the buyer, when the buyer collects damages, same as in the listing, by suit, settlement, or otherwise, compensation shall equal 1/2 of the damages recovered, not to exceed the compensation provided for in paragraph 4A. Meaning if you agree to pay me 2.5% and the seller defaults and the buyer sues the seller and gets money back from the seller, you as the broker or the agent of the broker are entitled to 1/2 of what the buyer gets, the same as in the listing agreement. So but I also caution you, I'm devil's advocate here, so I also caution you that that even though, yes, you're entitled to 1/2 of that compensation, yes, absolutely, do you still want to work with this buyer? Because that could put a damper on your relationship. I just say take these things into account. So anyways, all right, so we're still on 4. Good God. 4H, payment through escrow. This provides payment through escrow. 4I, pre-existing buyer representation or compensation. If the buyer acquires a property during the time buyer is obligated to compensate another broker, broker is neither entitled to compensation under this agreement nor obligated to represent the buyer in such a transaction. Meaning, if you enter into this agreement, but they are still obligated to pay somebody else, you're not entitled to anything. So why would you be involved? You just back away and say, you can, buyer who's being compensated can step in, or a listing agent can step in, and but still with the knowledge that they won't get any compensation. So 5, we finally moved on from 4. is agency relationship. One of the first things before we get to this document is an agency disclosure. So this talks about agency relationships and possible dual agency with seller. And it's when I say possible dual agency with seller, remember the agent is the brokerage. So there may be dual agency. Just because you as the agent aren't representing the seller, you're still part of the same brokerage. So it is dual agency. Just keep that in mind, and make sure you explain that to your buyers. That agency is the brokerage; it's not the individual agent. And once again, I get this all the time. And for you new agents, even though there are 4 different offices on this call or on this Zoom that I am the broker for, every single one of those offices has a different DRE number. So it is not considered dual agency if somebody from Calabasas and somebody from Studio City or Westside or Larchmont. It is not dual agency because they're different. They're different DRE numbers and corporation names. Broker authorizations, and this is the boilerplate of buyer authorizes broker, and broker agrees to use reasonable skill and due diligence. This is where you're selling yourself. This is what I'm going to do for you, Mr. Buyer. This is why you need me in this transaction, and you need to sign this agreement. If the property contains residential property if it's a 1 to 4, the broker, meaning you, will do an avid. You have to do a visual inspection of the property if it's residential 1 to 4. Broker shall deliver or communicate to buyer any disclosures. Broker services are permitted in compliance with the federal, state, and local anti-discrimination laws. We do not discriminate, and that became apparent. Or never mind, I won't get into that. Anyway, so that's 6. Oh, we flew through 5 and 6. Buyer's obligations. Hey, Mr. Buyer, you need to act in good faith. How many times have I said to an agent, I'm representing a buyer and he just changed his mind, but he's going to use this excuse to get out of this. That's not acting in good faith. And I'm devil's advocate here because I see these things go to claims, and it's if the seller can say this buyer is not acting in good faith, and they can prove it, then they can, in an argument over a deposit, they can possibly get that buyer's deposit. You have to be acting in good faith. 7B, personal and financial information. Within 5 calendar days from execution of the agreement, buyer shall provide relevant personal and financial information. Personally, I would want that before that you sign an agreement to represent a buyer. You want to make sure a buyer is a buyer before you get under contract with them, but that's me. C, reasonable care and other professional assistance. Buyer is obligated and agrees to read all documents. We all know that they don't read, but they are required to read, and you are required to go over the documents with them. Not just send them in a DocuSign and say, oh, initial and sign here. If you're working with a first-time buyer, even if it's a seasoned buyer, but they haven't bought in a while, you should be on the phone with them while they're going over going over documents. That's what I did with my clients. It's like, or now we have Zoom. We didn't have Zoom back in the good old days. We didn't have Zoom. We actually met with people and sat down and signed documents, but you should be going over page by page, paragraph by paragraph, and saying, okay, do you understand it? Now you can initial it. Do you understand it? Now you can initial it. Everything that they sign, you should be going over with. And guess what? If I were you and it was a Zoom, I'd be recording that Zoom because you have proof that you went over this stuff. Okay. Reports and investigations. Buyer agrees to pay for reports. You don't pay for any of the buyer's reports. Buyer material issues. Buyer shall notify broker in writing any material issue to buyer, such as, but not limited to, buyer requests for information on or concerns regarding any particular subject or interest or importance to the buyer. What does that mean? Buyer material issues. What does that paragraph mean? How many times have I heard that a buyer, I intended to add 5 stories to this house, and that was always my intent. You knew that. Well, it's like, no, you need to tell me what if the buyer intends to use a property as a rental, they should be telling you that. If they intend to do to expand the property, they should be telling you that. Now, you don't go out and find out if they can, but you can point them in the right direction to find out if they can, to do their due diligence. But or rents, you can do a search of, I plan on renting this. What do and I want to rent it for $5,000 a month. And they never tell you that. And you do your research, and the rents in that neighborhood is $2,500. It's like, are you crazy? If you had told me that, I would have told you never could get that. So that's what that means. Incorrect, incomplete, or inaccurate information. Buyer agrees to indemnify, defend, and hold broker harmless from any claims, disputes, litigation, attorney's fees, blah, 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 arising from information supplied by the buyer or from any material issues that the buyer fails to disclose in writing to broker. Going back to E. Sorry. Attorney's fees in any action, proceeding, or arbitration between buyer and broker arising out of the agreement. Buyer and broker are each responsible for paying their own attorney's fees, except in paragraph 9A, which is very next, which all agreements, you have to mediate first. So that's the agreement to mediate. And then 9B, the mediation terms. Advisories, all these other advisories are attached to this document. I'm just not showing you them. Number 12, the entire agreement, in all understanding between the parties are incorporated into this agreement, and then basically any other terms have to be in writing. And then entity buyers, if they are an entity, you use this replaces the RCSD. So that's that. Okay. So that is the buyer broker agreement. There was one other form that I wanted to go over with you. Any questions on that before I move on? Sorry. I'm not seeing any. Okay. The other thing I wanted to go over with you is I told you that there was something in place already for the seller to pay this money. So, Siri is talking to me because she didn't understand what I was saying. So in the RPA, which confused everybody, I should have looked it up, but I can't remember. Actually, I probably can look it up here. Well, you guys are looking at this. Oh no, my session expired, so I'm not going to bother with that. Let me go back to this. Okay. Um, one of the paragraphs put in seller payment to buyer's broker, and it confused everybody. So you use this form. You can use this form if the seller isn't paying any compensation, to ask them to pay for your compensation in the RPA, because commission terms are not a part of the RPAs. An agent said something, oh, I'll just put it in the RPA that, I'm cutting my commission, but it's like, no, it doesn't go there. Because brokers aren't a party to the the uh, the contract. They're not number one, they're not a party to the contract. Number two, it is a huge, this is the problem. This is the problem that we were getting in. It is a huge antitrust violation to put compensation and anything like that in the RPA. This has been approved by lawyers. This is the only thing that is okay to do. And this is asking the seller to pay for the buyer's obligation to pay compensation. And this is only used when there is a buyer broker agreement in place. That's the only time you can see it. Only use this form if little I, buyer and buyer's agent, has already entered into a buyer representation agreement. Or 2I, buyer has an obligation to pay buyer broker compensation pursuant to a representation agreement after first deducting any amount that the buyer broker will be receiving from seller broker through the MLS. What does that mean? That's the case where the buyer agreed to pay the buyer broker 2.5%, but the seller is only paying 2%. So you're asking the seller, please pay the extra 0.5%. Okay. Or 3, buyer is asking seller to pay buyer's broker all or a portion of the balance due to the buyer broker under the representation agreement. So, like I said, in the case where they're offering nothing, you can ask them to pay you. So, okay, Veronica, you had your hand up.
Yes, just to clarify, this form only applies, like you said, when when the buyer's agent has that exclusive buyer and broker agreement.
Doesn't have to be exclusive.
Okay.
It just could be that there is a buyer broker agreement in place, but it doesn't have to be exclusive. Good question. Thank you.
Okay. Thank you.
So, and you see, notice the amount or rate of real estate compensations is not fixed by law. They are set by each broker individually and may be negotiable between seller and broker. Real estate commissions include all compensation and fees to broker. It has to be everywhere. Negotiation, commissions are negotiable. Okay. And you'll note above that, seller may accept, reject, or counter this term as with any other term in the buyer's offer. So just because you're asking for it doesn't mean you're going to get it. Okay. So the number one says buyer representation agreement with compensation. Buyer has entered into a written agreement compensate buyer's broker, let's say 2.5% of the purchase price. So you first have to say what the compensation that you have agreed on. So number 2, compensation from seller's broker to buyer broker. As of the date, this seller payment for buyer broker document is signed by buyer and pursuant to the MLS, or this would also be the CBC, not the bullet test. Seller's broker has agreed to pay the buyer broker X percent of the purchase price. So number one says buyer agreed to pay me 2.5%. In number two, pursuant to the MLS, wait, let me make sure that I'm reading this right, because wait, as of date, buyer broker signed by the word, and pursuant to the MLS, seller broker has agreed to pay. Okay, so if there is an amount in the MLS, so number one, buyer agreed to pay me 2.5%. Number two, seller agreed to pay buyer broker 2%. So, okay, now we're establishing buyer's obligated to me for 2.5, seller is only paying 2, or that could be 0. So if they're not offering anything, that is 0. Okay. Then seller payment to buyer broker shall not be greater than the amount in paragraph 1 minus the amount in paragraph 2. So in my first example of buyers paying me 2.5, sellers paying me 2, that amount would be 0.5%. I almost said 5%, but no, 0.5%, because you're asking them to pay that extra 0.5%. In my second example, where buyers are paying me 2.5% and sellers paying me 0, you're going to ask for 2.5%. You're going to ask the seller to pay 2.5%. Okay. Any questions on that? Once again, only if there's a buyer broker agreement. Okay. So number 4, buyer authorized escrow holder upon request to deliver seller a copy of the portion of the written agreement between buyer and buyer's broker, meaning that escrow is going to get a copy of your buyer broker agreement to see that you agreed to pay this, and they're going to supply it to the seller to make sure that you're telling the truth. Okay, so if buyer's broker is the same as seller's broker, then the amount specified in the MLS shall apply in the manner specified in 2 and 3. Additionally, if broker has agreed in the listing agreement to a reduced amount of compensation in the event of dual agency, the amount of compensation specified in the MLS will still apply to offset the compensation that the buyer has agreed to pay buyer's broker. Okay, I need to digest this. What this is saying is, okay, if in the listing agreement you're reducing your commission, the broker has agreed in the listing agreement to reduce the amount of compensation in the event of a dual agency, the amount of compensation specified in the MLS. Okay, so what that's saying is, because remember, broker is the brokerage, not the agent. So if one agent agrees to cut their commission by X amount of dollars, if it's a dual agency, technically this would be a dual agency, but it's the amount that's offered in the MLS to cooperating brokers that's deducted to offset the amount that you're asking. So this is when the listing compensation is variable. Yes, that's called variable. A lot of agents don't know, is compensation variable? A lot of listing agents don't know that if you have such an agreement, you have to disclose that in the MLS. And how do you disclose that? Is the compensation variable? Meaning, does it change? And the answer to that is yes. If it's dual agency, which in listing agreements you need to specify that dual agency, if I'm representing, meaning this particular agent, I, the listing agent, I, Rich Pisani, represent you, seller, and the buyer. If I, Rich Pisani, represent both the buyer and the seller, then my commission will be reduced to X%. Not that Williams Studio City represents them, because any agent thus reduces the compensation. So everybody understand that? Thanks for bringing that up, Omid, because a lot of agents don't know that. Okay. So this is how you can, if seller's offering 0, how you can get them to pay. And which brings me to, oh God, I can't remember who asked the question. Was it Sherry? I think it was Sherry, about can this amount be financed or something like that? Okay, so this is how this is going to have to play out, in that right now you cannot finance the commission. Now that commission is going to go against, a buyer's ability to buy something. So sellers, it becomes a negotiation of, seller, will you please, cover this commission, because the buyer can't qualify otherwise. So that's number one. Number two, there is talk about commission being financed. That talk is out there. Right now it's not allowed, but that talk is out there. So my guess is, as our industry changes, then this will also change. There will be that ability to finance the commission on the buyer's side. And then there'll be another lawsuit saying I'm paying more commission because I'm paying terms about it. But anyways, I can't do anything about that. Any questions on this form? Because we've now done all of the buyer broker agreement. You're all gonna start using it, and you're all gonna be experts at it. And number one, you have to sell your worth. You have to. This idea of them running to the listing agent, I really need to dispel that from your mind, because I don't think that's gonna, because you have to sell your worth to tell them, Mr. Buyer, that agent has a fiduciary duty to that seller. So if there's representing both of you, I know some of you do it, and I've done it like twice in my career, and it's a fine line. So and it wasn't fun. I didn't like it. So anyways, you really have to sell yourself. And I know that all you can do it, and then I know that you will excel. And are there any other questions before I close this out? Oh, Veronica, you have a question.
Yes.
Oh,
Quick
yeah.
question. When does the notice of broker involved properties form apply?
It applies when at the expiration. It especially applies at the expiration or the cancellation of the agreement.
Got it. So that's why you were saying we need to keep record of the properties showing. Okay, that makes sense. Thank you.
Great. Uh-huh. Anything else? All right. Well, I thank you so much. I am gonna stop.
Thank you, Rich.
Thank you all for joining me.
Thank you.
I hope you all got something from this. I can't find the recording here, but it'll end when I end. Okay. So go out there and go sell and use these forms, because don't make the state make them mandatory. Let's just make it a normal practice. Okay. Thank you.